Good afternoon, and thank you for joining Venable's presentation on Crypto in Focus, Legislative and Regulatory Shifts, Banking Access, and Legal Risk in 2025. My name is Andrew Bigart. I'm a partner in Venable's Financial Services Group, where I focus on helping banks, payments companies, and fintechs work together to develop financial services for consumers and businesses. I'm joined today by my colleague, Chris Boone, also a partner in Venable's Financial Services Group. Chris has a particular focus on regulatory compliance issues related to cryptocurrencies, token platforms, and NFTs. So I'm very happy to be presenting with Chris today. Chris, you want to say hello quickly to the audience?
Sure. Yes, so I'm Chris. I'm with Venable, and I do payments and blockchain, cryptocurrency kind of specific work, and happy to do this presentation to kind of walk through all the different changes that have been happening in the kind of crypto universe.
Great. So let's go ahead and start with a look at the agenda for today. As you'll see, our goal is to give you kind of a broad understanding of recent regulatory and legislative, in particular, developments in the crypto space, and some information on how they may impact payments and other financial services. We'll do a quick kind of overview of the basics of these, then move to kind of a more detailed discussion of legislative developments and regulatory considerations. We will be providing CLE credit for this program, and so we'll provide the code halfway through, and then again, I think at the end of the program. And of course, this presentation will be available in the next few days on Venable's website. But kind of stepping back for a moment, part of why we're presenting today is because we're really on kind of the verge of some big changes in the growth and development of the cryptocurrency industry. For those who've been following this technology, it's been well over 10 years since Bitcoin was launched. It's grown into a trillion-dollar industry. But some of the day-to-day applications in payments and other financial services have kind of proceeded through fits and starts. And a lot of that is due to the legal and regulatory challenges and some of the uncertainty that has been inherent in the industry. But that really seems to be changing kind of over the past year in particular. I know in our practice, we've seen more and more payments companies and fintechs leveraging the technology for things like cross-border payments, even starting to see traditional payment processing industry looking for ways to incorporate things like stablecoins into day-to-day payments. And with the expectation of kind of near-term federal legislation, which Chris will spend a lot of time discussing today, I think it's fair to say that the stage is being set for the technology to grow a lot in the next few years. It's not a coincidence if you follow the news that there have been major news stories in recent weeks about some of the largest merchants in the country exploring the use of stablecoins, one of the largest payment processors talking about launching a stablecoin platform as well. So a lot happening here. And with that, let's go ahead and kick it off with a primer on some cryptocurrency basics. And Chris, I'll turn it over to you.
Sure. So to kind of just level set the ground here, we need to explain like what cryptocurrencies are and what they're not. So a cryptocurrency is a blockchain or distributed ledger based token that is primarily used for payments or potentially store value for speculative purposes. But the underlying technology allows essentially users to send value without the need for an intermediary. And over a decade ago, this technology was first introduced through Bitcoin, which is probably the most famous cryptocurrency and what people most associate with blockchain technology. But cryptocurrency is only a subset of broader digital assets. Digital assets can include things like NFTs. They can also include non-blockchain based digital items. And so, it's important to kind of keep in mind that there are many different but strangely related areas of technology that are kind of wrapped up when we're talking about crypto. So what is blockchain then? Well, a blockchain is essentially a chain of blocks. All of the transactions from one period of time are kind of batched together, and that's a block. It's then hashed, which is like making a kind of a thumbprint of those transactions, and it's added to the next block. The technology is then super important to, or necessary to understand, but that's kind of the basic gist. And the people that are verifying these blocks are really their nodes on computers running a program distributed all across the globe, at least in the uh, at least in the context of an open and permissionless blockchain. There are permissioned blockchains that are more centralized, more similar to the current system of like a bank uh, type of system. So that's kind of funny in a way that one of the evolutions of blockchain has been uh, a, a, a tending towards systems that more reflect what we've had in the past. But there's just so many different technological variations. It's hard to pin any one down. So I kind of mentioned this a little bit earlier, but just kind of more in depth go over the different types of digital assets. We talked about cryptocurrencies, but there's also stable coins, and stable coins are probably the hot topic, what's the big deal right now. The Genius Act just passed the Senate, and that has everything to do with stablecoins. Stablecoins are a token that is supposed to reference some underlying asset. And there's another slide that will get into that a little bit deeper. But just to kind of uh, get a good scope, there's utility tokens, there's meme tokens, there's social tokens, central bank digital currencies, NFTs, all with kind of different roles. Just to give a little bit of color on utility tokens, that term was originally kind of created back in the old SEC days when developers were trying to distinguish their tokens from securities. They wanted to say that the token that they're releasing is not a security. So they would add some functionality to it. It could be like smart contracts or membership rights, coupons redeemable for goods and services, things like that, and call it a utility token. Previously, the Securities and Exchange Administration Commission did not agree necessarily with that characterization, that calling your token a utility token meant it wasn't a security. So the kind of terminology has not really caught on so much, but that's just some kind of history there. Of course, now the SEC takes a much more industry favorable view of tokens and cryptocurrencies, which we'll definitely get into later. So going back to stablecoins, they're designed to maintain a peg with an underlying asset, the most common of which is fiat, and the most common of that would be the US dollar. So 1-to-1, one token, $1. That's the gist, that's the idea. It should be used like dollars. That's at least the end goal, but using blockchain technology. So it'd have all the benefits of instant or near instant settlement and interoperability, smart contract usage, all the things that make cryptocurrency really appealing, but then applying it to dollars. That's a pretty powerful idea and goal. So then how does it work? Well, if you're having a fiat-backed stablecoin, there are a couple different models. There's the algorithmic model, and then there's the reserve model. The algorithmic model uses a lot of complicated math to try to use market forces and algorithms to ensure that the token stays at where it should be, $1. There are problems with that, and tokens that have attempted this in the past have failed in quite spectacular fashion. So the consensus is, you need a reserve model if you're going to have a legitimate stablecoin. So for every dollar a stablecoin issuer, or for every token a stablecoin issuer issues, they need to have $1 in reserve. That way they can redeem the token one for one, and that maintains the peg. if for some reason there was a fluctuation in the value, you could go and if it went below $1, people holding the token could go to the issuer and exchange it for $1. And so there really isn't a economic reason to sell for less than $1 because you can always redeem it. And there's no reason to sell for more than $1 because the issuer can issue the tokens for $1. So that's basically how it maintains its peg and creates price stability. Central bank digital currencies, Andrew would like to talk about.
Yeah, and I'm not gonna spend too much time on this just because there's less interest on CBDCs here in the U.S. At least under the current administration. So CBDCs, central bank digital currencies, essentially, it's a digital version of a country's fiat currency that's issued by a country's central bank or monetary authority, right? So, it could be the digital dollar, for example, would be kind of an example of that. And interest in CBDCs has kind of gone up and down a little bit over time, and definitely in different parts of the world. It's been looked at and kind of experimented with in Europe and in China, but certainly hasn't had really any kind of mass implementation yet. And here in the U.S., under the Trump administration, there's actually been a ban that's been put on kind of CBDC for various different reasons. Part of it is focused on all the kind of the private innovation that's happening, but also there are some concerns with something like a CBDC around individual privacy rights, financial stability, national sovereignty, and the like. And so I think while it's an interesting idea, and I think you're going to continue to see other countries probably experiment with it, it's really not something to focus on in the near term, at least not here in the U.S.
So that's a good segue to cryptocurrency under the Trump administration. Clearly, there's been a 180-degree change in approach to cryptocurrency and blockchain technology generally. So the Trump administration has stated some pretty clear goals for what they're wanting. They want to reduce the regulatory burdens on the cryptocurrency industry. They want to promote digital asset adoption more generally, and I quote, make the United States the crypto capital of the planet. So those are some pretty big goals. So what has actually happened? How are they going to achieve those goals? Are these just words, or is there actually action happening? And action is happening. There have been several digital asset focused executive orders. You can just see, Trump and family issuing their own meme coins and speaking about ending Operation Choke 2.0. And in the administrative agencies, FTC, CFTC, and Treasury have been, their appointments have been pro-cryptocurrency, having pro-cryptocurrency viewpoints, and that has been reflected in many of the regulatory guidance that's been issued in the past few months. So looking at the first digital assets executive order from the Trump administration, the key takeaways were essentially erasing the past. So the frameworks and guidance issued under Biden were essentially removed wholesale. And then Trump established the working group, which was a task force to develop a federal regulatory framework for digital assets. And that looked and coordinated with agencies across the federal government to coordinate and come up with a kind of a cohesive plan for how are we going to regulate this and what makes sense. And then I don't know if this is a surprise or not a surprise, but this is where we had the huge crackdown on the central bank digital currency concept. Previously, this was explored. Biden had some reports directed to be written and to be researched about the viability and if can this be done safely, and all of that's being shut down, in no way, shape, or form. will there be a central bank digital currency as long as Trump administration continues. So this has led to a bit of a crypto migration. Andrew?
Yeah, I mean, I think you've just seen, the support that you're seeing kind of from the administration and some of the legislative proposals that are out there that Chris is going to talk about. Just a lot of excitement and a lot more of a drive to kind of come back, I think, or come into the U.S. for cryptocurrency related products and services. I mean, to a certain extent, when there was a lack of regulatory certainty, there was a lot of maybe innovation that was not necessarily happening or being rolled out here in the U.S. because of particular risk. I think you're starting to see some of that reversed, and you're starting to see foreign-based companies really expand more aggressively into the U.S. And for those companies, there's still going to be regulatory challenges and issues that need to be taken into account. And when we get to the more regulatory focused portion of the presentation, we'll dive into some of these in more detail. But it's things like money transmission licensing and AML compliance, economic sanctions compliance, advertising and marketing that goes along with consumer protection. There can be state level regulations and even specific licenses separate from money transmission, and just kind of keeping on track of this evolving regulatory framework. So we're definitely seeing an uptick and an expansion here. But I think it's, anybody that is expanding in this industry needs to be mindful that there still are a lot of regulatory issues to keep in mind.
That brings us to the legislative updates. There are a number of crypto-focused bills that have been proposed. We're going to talk about two of them that I think the two that are most likely to be enacted. And the first up is the Genius Act. Excuse me. So the Genius Act is the stable coin bill. It regulates stable coins. And this passed the Senate just this month, June 17th. And so now it would go to the House to be voted on, be debated. If they change anything, there need to be a reconciliation in that kind of process. But this is really the first time we've seen a major piece of cryptocurrency legislation pass one side of Congress. And, it's still, to be seen whether or not this will end up as law, but currently it has the best chance. And then the other act that we're going to talk about in a little bit more detail is the Clarity Act. The Clarity Act would be the broader market structure regulation. This would be how do you determine if a token is a security or not? Who's regulating the token and what standards do they have to follow? All of that is under Clarity Act. And that is currently in the House. It's been advanced out of committee, and that's currently where that is sitting. So what are the key takeaways then from the Genius Act? Well, it's the most advanced federal legislation yet on stablecoins. It's set to fill out the regulatory vacuum that's existed since stablecoins like USDC and USDT have entered the market, which was years ago. And so what it would do is, one, it would require licensing requirements for issuers. So if you are issuing a stablecoin, you will need to be licensed. Significantly, it's not going to be limited to banks. Non-banks will be able to become licensed in order to issue stablecoins. And importantly, one-to-one reserves. I mentioned this earlier when we were talking about stablecoins and how they maintain their peg. And I think rightly, the act is requiring stablecoin issuers to have one-to-one reserves in order to guarantee redemptions. These reserves have to be in highly safe assets, so cash or treasuries, insured bank deposits, and things of that nature. The reserves must be segregated, audited, bankruptcy protected. They need everything in order to protect the system. Because if you don't have those protections, if you didn't have these requirements, then you could have a system where you have like a run on banks, so to speak. If the ability to redeem is compromised, then that would become a huge problem. Another interesting aspect of the Genius Act is that it bans interest-bearing stablecoins. So if you have 100 USDC, which is a stablecoin, they would not be able to issue you yield. However, that's not the same thing as the issuer being able to receive some benefit from the reserves that they have on hand, but they cannot leverage those reserves in the more typical banking sense. They can't, lend the reserves out or buy risky assets. They can only hold safe assets as reserves. Now, for regulatory oversight, this is pretty interesting. If you are an issuer and you have issued over 10 billion in circulation of a stable coin, you'll have federal oversight. If it's less than 10 billion, then you might be operating under a state regime. The way the bill works is that it allows states to implement their own regulations that have to meet, federal standards. And if they certify that their regulations meet these standards, then they may regulate issuers in their state who have less than 10 billion issued stablecoins. So it's an interesting interplay between like federal and state oversight. So what about the guardrails? Well, one of the strongest features of the Genius Act is its treatment of reserves. They have to be, again, in very safe assets, treasuries, cash equivalent. Anything resembling risk-taking, like corporate debt, equities, is off limits. So, that really can't be understated or overstated. And the ban on yield is also critical. This means issuers can't lend or invest or otherwise use the reserves for their own gain. They're walled off, just like client funds in a brokerage account. The Act includes robust redemption requirements. Holders must be able to convert back dollars quickly. It aims to prevent like a run on the banks type of situation and reinforce stablecoins equivalency to fiat. Because at the end of the day, that is the intended purpose of a stablecoin, at least a USD-backed stablecoin, is that it's to act like a dollar and have the qualities of a dollar just existing on blockchain. Interestingly, the custody rules will override the SEC's Staff Accounting Bulletin 121. And for those of you who don't know what that is, that Staff Accounting Bulletin told companies that if you had customer assets, like cryptocurrencies, on your books, you should treat those as liabilities. This would flip that around. So it would ban regulators from forcing custodians to treat stablecoins as liabilities. And that's pretty significant for those companies, for custodians, because it makes a tremendous difference to their books and business from an economic standpoint, how that accounting works out. I'm not an accounting expert, so I couldn't go into super detail, but it is definitely a big deal. So there have been a number of policy debates, different sides arguing about different ways to implement how this bill will be written. And one of the most significant kind of debates was, are you going to allow just banks to issue, or are you going to allow non-banks to issue as well? In the current language, the language that's passed the Senate, both banks and non-banks can be licensed to issue stablecoins. Of course, critics argue that this basically allows big tech, to issue private money. But on the counter side, is that they can foster innovation, that tech companies or private companies can lead the way in innovation and technology, whereas banks are slow to move. And there's truth to both sides of the argument. How it will end up, what language eventually will be passed, if anything is passed, is still yet to be seen. And then, kind of as mentioned earlier, there's this tiered system. The interplay between federal law and state law is always top of mind in creating a new regulatory structure. And in this case, they created this tiered structure based on this 10 billion mark of issued stablecoins. And so for the largest issuers, they will be exclusively under the federal regime. But for smaller issuers, they could very well be under a state regime. It might be the case that we'll see some states try to certify regulations. It might be the case we'll see a lot of states try to certify regulations to fit under the kind of certified regulatory regime structure that's kind of created here. It's an interesting process. Is really all I have to say. But I think the most notable one here is the shot clock, and this is really important. So if you are applying to be a stablecoin issuer, your regulator has to act on your application within 120 days. If they fail to act, it's deemed approved. Now, why that's important is because you can imagine the problem of a regulator who doesn't want to issue an approval, but doesn't really want to have to go through all the reasons why they don't want to. Maybe they can't think of enough reasons. It basically forces the agency to act and to put onto paper why they're denying, which can be challenged in court if there isn't a sufficient basis for the denial. And so this really puts, the momentum in the hands of issuers or would-be issuers. If this became law, it would be much more difficult for government to kind of stonewall or drag their feet for these types of companies. And I think it's really important to actually get things done, as I'm sure a lot of cryptocurrency or cryptocurrency adjacent companies faced back in the Gensler era. So there's no blanket preemption of state law, but state regulators will retain a role, especially for smaller issuers, which we've been talking about, to kind of go into a little bit more detail about that certified regulatory regime. The requirements the state would have to enact would have to be kind of substantially similar to the federal regime, and they would have to implement these new rules within a year. The certification review would take about 2.5 years. There's like a deficiency cure period, and there could be a federal override. So the Fed or the OCC may step in if the state regulated issuer seems to pose risk. There's not a whole lot of clarity on what that would look like. I believe rules will need to be written to kind of further flesh this out, but it's worth noting. And then there's also a provision that the states can voluntarily transfer oversight to the Fed if they want to. So why does this matter? Well, this is the first major crypto-related legislation so far to pass one chamber. It was very, very recent. It's very top of mind and topical. And stablecoins will become a pretty big player and technology kind of going forward. We're seeing in the work that we do a lot of movement to incorporate stablecoins in either like bank-to-bank settlement or more kind of consumer-facing with payment processors, fintech, all trying to look into and implement stablecoin systems. So this isn't going away. It's growing, and there's currently no regulatory structure for stablecoins or for stablecoin issuers. And having a regulatory system that says how you are supposed to do things, and these are what you need to comply, would be huge for the industry. It would legitimize it. It would give kind of the green light for banks and major institutions to further adopt the technology. And now we'll move to the Clarity Act.
Hey, Chris, maybe before you jump in on the Clarity Act, just let's do our CLE code here. So the CLE code is crypto 2025. That's all caps. Crypto 2025, and we'll repeat that at the end of the presentation too.
So the Clarity Act is in the House, and it is the general market structure bill. Its most basic deal is defining digital commodities versus securities. That's like the big gist. There's a lot of things going on, but if you had to sum it up into like one sentence or like one point, that would be it. So the way it works is that it will codify a digital asset sold under an investment contract itself as not a security. It creates a distinction between the investment activity and the underlying token. This is a concept that's been brought up before, but this would make it into law. That way you can have, let's say, an ICO, initial coin offering, which would be a securities type of transaction under even the proposed model. But the underlying token isn't necessarily a security. It was that original purchase, that original issuance transaction that is the security. And afterwards, once the token has matured, it loses that security status and becomes a digital commodity. So it kind of transfers from one legal bucket into a different legal bucket. It also creates a pathway for exempt offerings if certain disclosures and other requirements are met. And again, once the token reaches maturity, it's treated as a commodity. The disclosure regime would include like tokenomics, risk, governance, all the things that you would expect in a kind of a securities offering disclosure would still be required, but it's a more limited pathway depending on certain requirements. Investor protections are included. This includes like resale restrictions, lockup periods, of course, more disclosures and anti-fraud backstops. So this really goes to kind of insider trading in a way. So to prevent insiders from dumping tokens on retail investors, the Act places graduated limits on token sales by insiders and affiliated persons. For example, a core team member and significant token holders are subject to selling restrictions that taper off as the blockchain network approaches maturity. This concept is pretty similar to lockup periods or Rule 144 in securities law, kind of aiming to align insiders with the long-term success of the project, and of course to prevent quick pump and dump type schemes. So the Clarity Act gives primary authority to the CFTC as the kind of primary regulator for spot markets and digital commodities. This is a significant shift in federal crypto oversight. currently. It would also create different buckets and tiers: the digital commodity exchange, digital commodity broker, digital commodity dealers that would be subject to the CFTC's authority and CFTC rulemaking. So these digital asset firms would need to meet robust obligations akin to those in traditional securities markets. For example, they must segregate customer funds from the firm's own assets. They are required to provide clear disclosures to customers about fees and risks, conflicts of interest. They need to establish conflict of interest policies, comply with conduct standards set by the CFTC, membership in a registered futures association is required, like the RFA. That would be mandatory. And there are also qualified custodian requirements. So as you can see, it's not like there's going to be no regulation here. It would be a really robust regulatory framework, but treating it more as a spot trading of commodities instead of treating it as trading of securities. The Clarity Act also makes an important note. While it might seem obvious to some, non-custodial actors, those who do not hold or touch cryptocurrencies, this might include developers, validators, the Act says explicitly that these will not be treated as financial intermediaries or money transmitters. So they will not be subject to money transmission laws. Now, I've argued in the past, how money transmission laws apply to people and businesses in the cryptocurrency industry, and generally, the rule of thumb is if you're not holding, not transmitting, then the money transmission rules don't apply. But there are cases where that kind of rule of thumb doesn't always line up with reality. And so by having this in the law, that protects developers, protects validators who are not holding funds on behalf of anyone from the threat or fear that they could be at risk of non-compliance. So again, there have been a lot of policy debates that surround the Clarity Act. One is the big one, digital asset versus security. This act will codify the evolving view that digital assets are separate from the investment contract analysis, that tokens can mature, and not every token is a security. That's kind of the choice that this legislation makes. And another big one is preemption. So how does this work with state law? Well, interestingly enough, the covered digital commodities would be exempt from state level securities registration. And the way they do this is by calling them covered digital securities in the law. They're actually called covered digital securities under the law, even though they're not being regulated as securities on the federal level. But the reason for that is that designation makes them exempt from state level regulation of securities. So the federal level regime would replace the state level regime in terms of securities regulation. And then the last bullet here, self-custody affirmed as a legal right. You might think that this is, obvious. So obvious, why do you even need to have it in the bill? But maybe it's not super obvious, and there actually could be a very, very good reason to state affirmatively that regulators cannot mandate that users hold crypto with intermediaries. I couldn't imagine if that were the case, that would be not very fun for a lot of people who hold cryptocurrencies, because that would mean they couldn't hold them personally. They would have to let someone else hold them for them. And I can see a government reason why they might want that. I can understand that viewpoint. Uh, so it's good to see self-custody affirmed as a legal right from from the viewpoint of a fan of Bitcoin and cryptocurrency. I can see how that would be a policy move they would favor. So how does this interplay with money transmission laws, though? Now that's an interesting question because under the Clarity Act, there are requirements for complying with BSA AML rules that the CFTC will require. So there's still going to be state or still federal money transmission regulations. But the big question is whether or not the CFTC structure that they come up with will supplant the existing money transmission laws, either on the federal level, like the actual like Bank Secrecy Act that currently exists, or on the state level. There's no express language saying that there is preemption of the state money transmission laws, except for in one case. In this one case, which kind of mentioned earlier, non-custodial actors would be not money transmitters, not money transmitters under federal law. Now, again, that's kind of the way it should be anyway. Someone who's not holding funds, not transmitting funds, wouldn't be a money transmitter. So as far as preemption is concerned, it's not preempting much, so much more as it's assuring and making concrete this kind of determination more than an actual preemption. So now we'll kind of move into regulation and compliance issues. These are the kind of current sets of regulations and how they're currently being implemented today, as opposed to the kind of speculative in theory if these acts are passed type of way.
Yeah. I mean, on that to your point there, as you just talked, Chris, there's going to be, it seems like a lot of change on the horizon when it comes to cryptocurrency and digital assets. But there are, existing regulatory concepts in the event that that legislation doesn't move forward. And then even if it does move forward, there's still going to be a lot of existing regulatory requirements. It will still be relevant. It may, in some cases, it may depend on kind of the facts and circumstances, like Chris talked about, when exactly might a state money transmission law apply versus being preempted. But there's still going to be a lot of different issues to consider. So kind of looking at the world as it exists today or historically, one of the big challenges have been just kind of defining cryptocurrencies and the different use cases, and then trying to figure out where do they fit under the existing legal frameworks. And you can see how the legislation, Clarity Act is designed to kind of address a lot of these different issues, because for a long time the questions were, is a cryptocurrency or a different type of digital asset? Is it a security? In which case, it's Security and Exchange Commission has jurisdiction. Is it a derivative? Is it a commodity? Is it a substitute for currency? In which case, is it a kind of a form of money transmission? These were a lot of the issues that were being addressed and having a lot of uncertainty around. Consumer protection laws and regulations are always a key issue, and that goes in many cases much more to kind of the marketing and advertising of different products and services, and whether they're being deceptively marketed, whether all the material terms and conditions are being disclosed, et cetera. And then there's even issues of, what's the tax treatment of a particular cryptocurrency in terms of, property or an asset, and the IRS has looked at that. So all of these different issues have been a challenge, and that's a big part of why the Clarity Act is being kind of pushed, and what I think it's hoping to accomplish is to provide a lot more clarity, for lack of a better term, on these issues. So, but let's keep moving through kind of the current regulatory framework and some of the issues to keep in mind. So Chris talked about anti-money laundering and state money transmission risks. In the U.S., there's a very robust legal framework for AML for financial services companies, and it applies based on either the type of entity you are, if you're a broker dealer or a bank, or if you're a licensed money transmitter. There are kind of different obligations that you may have from an AML perspective. And FinCEN is the federal regulator that sets forth those regulations. For money transmission, if you're a non-bank and you're engaged in receiving and transmitting funds from kind of one place or person to another, that's viewed as money transmission. It requires registration at the federal level, kind of the implementation of an AML program, and compliance with a number of other AML obligations. Transmitting, exchanging cryptocurrency, so if you're an exchange or a wallet provider or a payment platform, it's possible that you could engage in money transmission under the FinCEN regulations and have to follow those requirements. Same at the state level. If you are, receiving and transmitting funds as part of exchanging cryptocurrency or just transmitting it, that can require state licensure in 49 jurisdictions, states plus Washington, D.C. And the requirements you have are customer identification and due diligence, monitoring and reporting on suspicious activity, and making certain other filings. Economic sanctions compliance is also a big issue. These are the kind of the rules administered by the Office of Foreign Assets Control, or OFAC, which sets forth lists of prohibited persons and entities, and also has kind of comprehensive programs that they implement against specific countries, right? So making sure that the services that you're providing are not going to persons on prohibited lists or moving through countries that are subject to embargoes, and that the kind of the diligence and blocking is being done to ensure that you don't violate those OFAC rules. Chris talked as well about SEC and the securities and kind of when do crypto tokens get brought under the Securities Act. I think we've kind of covered a lot of that in connection with talking about the Clarity Act. I do want to talk about banking agencies as well. So the OCC, the FDIC, and the Fed have been very focused on kind of providing taking kind of a safety and soundness approach to how banks provide services involving cryptocurrency, and going to the custody, deposits of assets, and even going to stablecoin issuance. And there's a lot of changes that we're going to get to in the next few slides that kind of go to that. So I mean, there's just a lot of regulatory issues that get kind of swept up when you're talking about providing, payments and other related services using cryptocurrencies. I think we can go to the next slide, Chris. I think we've covered a lot of the money transmission, but it is kind of worth noting that 3 states have adopted specific cryptocurrency regimes governing virtual currency business activities. You can see them up here on the screen. You've got the California Digital Financial Assets Law, which requires licensing and kind of various other standard compliance obligations. That is not fully implemented yet, but will be over the course of the next year. You've got New York's BIT license, which has now been around for several years. And then Louisiana as well has a statute that covers that. So it's not just at the federal level where there is activity. There's definitely states that are also looking at some of the regulatory issues associated here. Next slide, Chris.
So yeah, pivoting back to the kind of federal level, there has been a tremendous shift in how the SEC has approached cryptocurrency. So as I indicated kind of earlier, the old Biden era guidance has been withdrawn or rescinded. And in place of that, there have been a number of staff statements, and that will set kind of the new policy of the SEC going forward, at least until there is a bill passes Congress and is signed into law that would reformulate everything. But so for now, the crypto task force and SEC's enforcement reset has produced a number of staff statements, and those include the statement on protocol staking. So staking, if you don't know, is basically where a protocol level token allows you as a holder of the tokens to stake them. And when you stake them, you get a return. You're basically locking up your tokens into a pool, and by locking them up, you're serving a service. You're doing a service by helping to validate transactions. It's called proof of stake, a very different technology than proof of work, which is how Bitcoin works. That's very technical and not super important or relevant for this discussion. But the SEC is saying that when you're doing these staking services on a protocol level, that's not a security. Previously, there were questions if that was the security. And it's not just you doing it, also service providers that are facilitating that staking would not be considered engaging in the offer or sale of a security. So, if you have an exchange and on that exchange, you can buy tokens that offer staking, and the exchange wants to offer a service where they'll allow you to stake the tokens that you've purchased, and that exchange does that for you. The statement from the SEC says not a security. Similar statement for mining activity. If you are a miner, you're running a computer to mine Bitcoin or some other type of cryptocurrency, not considered to be securities activity. Stable coins, not going to be securities. And in the stable coin sense, I think that makes a lot of sense that they're designed to stay pegged one to one. I don't, where the expectation of profits would be there, but that's that statement, again, not securities. And meme coins. This one's fun. The SEC in its staff statement likened meme coins to collectibles like trading cards. Their value is speculative. If you have a rare Pokemon card or a rare baseball card, the value can fluctuate, and there isn't any enterprise that's trying to make a business out of it or something like that. That's the reasoning the SEC statement has given and has deemed them to be not a security. There was some pushback. One of the commissioners wrote a counter letter arguing what even is a meme coin. We can't provide a definitive definition, and so this staff statement is, doesn't do enough for clarity. And so it's kind of interesting to see some of the infighting at the commissioner level at the SEC. The SEC also issued broker-dealer FAQs. And this kind of goes to show there are still tokens today that the SEC would view as securities. And if you're in that bucket, you have a cryptocurrency that is a security, then broker-dealer possession and control rules will apply to you. But if you're just dealing with cryptocurrencies that are not securities, then they do not apply. The SEC also issued guidance to help issuers of cryptocurrencies that are securities on how to comply with disclosure requirements. So if you are issuing a security, you have to disclose things like your business. What does your business do? What are the risks? what securities are you offering? When you apply those disclosures to kind of a cryptocurrency type of business or a crypto token offering, how do you make those disclosures? And this guidance basically offered how the SEC views that guidance to look like, those disclosures to look like, what type of risks need to be disclosed to kind of give industry kind of a framework like, okay, we can do it and this is how we're going to do it. And just to kind of go back for a second, they're not that far back. In addition to all those staff statements, there was an enforcement reset. You've probably seen in the news, the SEC has closed or dismissed a multitude of investigations and lawsuits tied to crypto exchanges, NFT platforms, staking services, token issuers, and those have all been kind of basically put on hold and a pause on kind of new actions. And that kind of leads us into the banking side.
Yeah, and these are kind of the last few slides here as we get towards the end of the presentation. And you can see on the screen kind of the core concepts that have always been front of mind when it comes to the banking regulation. You've got safety and soundness, BSA, AML, third-party risk management, and then just kind of operational risk management and cybersecurity. And these concepts are all obviously very relevant to a bank that is engaged in cryptocurrency related activities. I think it's worth talking a little bit about the change that we've now seen kind of from the Biden administration to the Trump administration and thinking about what that means for banks moving forward. Under the Biden administration, there was definitely a much more cautious approach from the banking regulators on banks and their cryptocurrency activities. The policy guidance that was out there, was that banks had to notify their regulators before engaging in activities. They had to show that they had appropriate kind of risk management, consumer protection, and other programs in place. And those, were being pushed at the time by the regulators because of concerns around safety and soundness, BSA, AML. And importantly, there was also under the Biden administration a real focus on third-party kind of risk management. And so all of this was kind of happening together at the same time to create a pretty cautious environment. That is, starting to change. Chris, we can go to the next slide. Under the Biden administration, it was about, risk management frameworks, having, enterprise-wide support, board approval, due diligence for, onboarding, kind of the auditing and all that other stuff. These, were kind of the big expectations that were in place. And again, within the context of the regulators viewing, crypto asset activities as being novel and kind of higher risk. That was kind of where we are today. Moving to the next slide, we've seen a pretty rapid change in policy direction from the Trump administration. The banking regulators, OCC, FDIC, Federal Reserve have kind of issued new interpretive letters allowing for banks to engage in various different crypto-related activities, from custodying to participating in verification networks, et cetera, without having to kind of provide notice and get a non-objection bank from the regulator. And I think these letters are obviously dovetail with the Trump administration's view on cryptocurrency, but also as a response to the perceived debanking that was kind of happening under the prior administration. I think next slide. But I think it's still important to understand that even with kind of the change in Washington, conceptually around cryptocurrency, that this is still an industry that I think banks, from a regulatory compliance and third-party risk management perspective, need to be careful with and to treat as an industry that does need due compliance and oversight, right? Even under the Trump administration, in the past few months, there have been enforcement actions against banks involved in fintech programs for regulatory lapses, right? So it's not that there is no risk in this area now. I think there's still risk, but I think it's risk that banks that are interested can now kind of manage and move forward by just kind of doing your standard, appropriately tailored risk management programs, right? And I think that's what the Trump administration is pushing. I think Congress in passing legislation will help also provide a runway for that. But again, just to kind of tick off, what are the core requirements for risk management? Well, the regulators will still expect to see kind of enterprise-wide risk assessments before moving into supporting a new industry. There's always a big emphasis on making sure there's board oversight and approval and monitoring of these kind of programs, making sure you have the right staffing and resources so that you can actually implement your compliance and oversight and do it well. Due diligence of partners and then at different products and services that you're supporting, making sure you have the right contracts and protections in place. And so you can do your audits, you can do your monitoring, and then having an exit strategy as well in the event that regulatory winds shift in a different direction again in the future, which can never be fully predicted. So I think we'll definitely expect to see more banks getting involved in this industry, but I think that it will be done, I hope, in kind of a controlled and careful manner at the same time. And Chris, I guess last any concluding thoughts
Yeah.
from your perspective?
Yeah, so as we kind of wrap up, I want to highlight the big picture here. We're seeing a fundamental shift in how the US approaches crypto regulation. Federal agencies from the SEC to the OCC and DOJ are moving away from the prior administration's reliance on enforcement actions towards creating clearer and more durable policy frameworks. And at the same time, Congress is advancing major legislation like the Genius Act and the Clarity Act to provide stablecoin and digital asset oversight. But this is still a fragmented landscape, and banks and crypto firms kind of still need to navigate overlapping federal and state laws. So, this is all to say that this is all coming and it's coming really fast. So for organizations that want to succeed in this space, they still need to prioritize robust risk management, multi-jurisdictional compliance strategies, and ongoing dialogue with regulators. This is a fast-moving environment, and staying informed and proactive will be critical.
Great. Well, that takes us to the end of the presentation. Thank you very much for joining. The CLE term again is Crypto 2025, all caps. And yeah, thank you very much. I think this presentation will be up on the Venable website. And if you have any questions on any of this, give Chris Boone a call. As you can see, he knows his stuff really, really well. So thank you, everyone.
Thank you.